Hello everybody, just updating Twitter, if it didn't, checking to see if it updated automatically. Alright, it did. Alright. Hello, can you hear me? I have the microphone hooked up. Awesome, thank you. Okay. Alright. Let's see. So today I'm going to be talking about, or tonight I'm going to be talking about prosecutors, because there's a lot of talk in general about prosecutors need to be, great, thank you. Thanks, Phil. Anyway, so there's a lot of talk that prosecutors need to be held accountable for, sorry, I'm a little distracted right now, I had a different page up and I don't know where it is. There it is. All right. Prosecutors taking on cases that we feel don't make sense for them to take on, that they shouldn't be taking on, especially if a case results in an acquittal. You know, you look at the fact that there was no evidence to prove that the crime even happened, or there was obviously tons of evidence that the crime didn't happen, or that the complainant is completely not credible, or that there was tons of evidence to prove that they were lying about what they said happened. So, you know, there's this question about why are prosecutors, in Canada anyway, why are prosecutors taking these cases? So basically, the answer to that is that they have prosecutorial discretion. And it's a very broad term. It's a very broad power. They represent the state, so they're given a lot of discretion in how they make their decisions. Now, the other question is, well, isn't the purpose of the police investigation to determine if charges should be laid and if a prosecution should even occur? Well, in Canada, that varies from province to province to province, and I'm in Ontario, so I focus on Ontario, but I do know BC is different from Ontario in the way that the cops in British Columbia have to consult with the prosecutor. They have to before they can lay charges. This is my understanding. But in Ontario, they don't have to consult with the Crown. They can just lay the charges, name them, lay them, arrest, and then hand it to the prosecutor if they will take it. And then it's up to the prosecutor if they will take that case. So in cases, one of the, all right, there's a list of criteria that prosecutors basically have within their discretion to determine if they're going to take a case. So the first one is the seriousness of the offense. So we would think murder, or some kind of, physical assault or high treason or something like that. Mitigating or aggravating circumstances. I don't know. I'm not really sure how that fits into the picture. That's something I'm used to seeing in terms of sentencing and the level of sentencing that the judge or that they will impose on the convicted person. But nonetheless, I guess the Crown considers that in terms of whether or not they should take the case. So then the next thing is age, intelligence, physical or mental health, or infirmity of an accused. So they will take the physical condition of the accused person into account. However, we have seen 98-year-old men being accused of horrible crimes from 80 years ago or 70 years ago, 60, whatever. So obviously, again, this is something that the Crowns don't have to, put a check mark next to or whatever. This is something that they decide whether or not it's a determining factor in taking the case. The next thing is the accused's background. So obviously, if the accused has a criminal record or criminal background, they automatically assume that this person is generally a criminal and that they need to be brought to justice again. And then the next one is staleness of the offense. Now this one's interesting. Staleness. So to me that would sound like a historical offense. Something that happened X amount of years ago where obviously there's not going to be any evidence or very little. It'll be very difficult for either the Crown to have evidence to prove their case or the defense to have evidence to properly defend themselves. So that one's an interesting one. And then likely effect of the prosecution on public order and morale or on public confidence in the administration of justice. So the public order and morale or on public confidence in the administration of justice, that's an interesting one too. Basically, the morale of the day will help to decide whether or not they're going to lay charges. Well, what era are we in right now? We're in a Me Too era. We're in an era where we're being told that sex crimes are happening all over the place. The prevalence is ridiculous. It's out of control. It's an epidemic. We need to stop men from raping. We need to teach them blah, blah, blah. Well, right now, our Crowns, we have many of them who have this ideology that it's right now, it's in the public interest to prosecute every sex case that comes to them and to tell the police to hand it to the Crown regardless of what evidence they have. And then another one is prevalence of the alleged offense in the community, which is similar to the one that I just talked about. So again, prevalence. How do we know what the prevalence is? Based on numbers, data, arrests? I don't know. But again, in the age of, Me Too that we're in right now, there's all kinds of false data flying around. Something like 2% of sex crimes are actually prosecuted and convicted. So prosecutors are taking sex crime cases on the assumption that more men need to be caught and punished and put away and brought to justice for what they're doing, because apparently we've been letting them go and making it too easy on them. And then whether consequences would be disproportionately harsh or oppressive. That's an interesting one. And of course that can be perceived and interpreted in many different ways. It can be oppressive to an indigenous person or a native person, a black person, someone who's generally considered a minority, or an overrepresented in the prison population, women. It would be oppressive to punish a woman. But, is it considered oppressive if you are prosecuting a man who was accused of a crime that happened 20, 40 years ago, allegedly, and was never reported until 20 or 4 years later by some woman who's likely crazy and mentally unstable, or just has a hatchet to bury? So, these are all very open to interpretation, and can evolve with the morale of the day. Whether alleged offense is of considerable public concern. Again, that's very subjective and open to interpretation, depending on what we're dealing with in the day. Attitude of the victim of the alleged offense to a prosecution. I'm going to say that would mean if they want to see that man prosecuted, the Crown will say, okay, then we'll do it for you. And it may be if they don't want to partake in the prosecution, they don't want to see him prosecuted, well, that can happen. That can result in a couple of different things. One, the Crown might drop the case because they don't have their witness, their key witness. Or two, they will subpoena and under threat of arrest that witness to appear as their key witness against their accused person. That does happen. And then likely the likely length and expense of a trial and the sources available. Well, obviously that's not an issue because they just run them anyway, regardless of how long they drag on for. The accused's cooperation in investigation and prosecution of others. That's an interesting one too. So if there's co-accused, in this particular, in this example, if there's a co-accused person, the Crown can basically offer somebody immunity if they agree to testify as a Crown witness. There's a lot of ethical questions around that in many cases. And then the last issue is likely sentence, whatever that means. Likely the prosecution will result in a sentence, I guess. I don't know. So these are the general criteria that the prosecutors have in their discretion to decide. And the other thing, obviously, is reasonable prospect of conviction. So when you put that together, the reasonable prospect of conviction, what does that mean? Well, remember here, I'm not a lawyer, so I'm not doing, legal academic stuff here. I'm interpreting this stuff as a layman and, civilian, a regular person. And the time that I've spent interpreting this and making sense of all of this stuff, and I'm sharing it with with the public and people who are very interested in trying to make sense of the justice system and what happened to them or their loved one, or if they're still, if you're still dealing with an ongoing case, you want to understand more about the law because your defense lawyer never really helped you with anything. I'm just pointing this stuff out, and I will give you the resource that I'm reading this from later on. So back to prospect of conviction. Well, first of all, the Crowns they're bound by an ethic that they cannot prosecute for the purpose of getting a conviction or winning a conviction. This is actually I think this is common public knowledge. They're supposed to act on behalf of the state to ensure that the accused person who's being brought to the court is being tried fairly. And that includes making sure that all evidence is disclosed to the defense that comes into the hands of the prosecutor, and that all witnesses, whether inculpatory or exculpatory, so what that means is whether they help the defense or help the Crown witness, all of that evidence has to be produced to the defense, and the Crown is responsible, ethically and legally bound, I believe, to make sure it is legally bound, yes, to make sure that the defense gets all of that evidence and that any witnesses who fall into these categories are called to testify in a trial. Well, as we know, this doesn't always happen. So, prospect of conviction, again, when you look at things like staleness of the offense and you look at a historical sex crime allegation, that's going to be a stale offense, alleged offense. That's going to be pretty stale. So, how do they have a reasonable prospect of conviction in that case, right? That would be the next logical question. Where's the reasonableness of that? Well, I would start with the fact that there is no statute of limitations on sex crimes. It's legislated into our law. So because there's no statute of limitations, our law is basically saying we consider some crimes to go stale and not worthy of prosecution, but other crimes we would never consider stale, no matter how old it was alleged, how long ago it was alleged to have happened. And these aren't cold cases I'm talking about, cases that were reported once, closed, and then reopened later. I'm talking about somebody walking into a police station for the first time making a claim that something happened to them 20 or 40 years ago. That's a stale claim, a stale alleged offense. So how is there a reasonable prospect of conviction? Well, we have, again, the legislature telling us there's no statute of limitations, so go ahead, proceed. And the other thing is the fact that there's no corroboration requirement. So if there was a witness who could have been inculpatory or exculpatory for the accused, or even the complainant, chances are they're not going to be around. If there's physical or material hard evidence that could also be inculpatory or exculpatory, chances are pretty good that's not going to be available either. Now, again, that brings us back to the question. So with that in mind, how can a Crown consider a reasonable prospect of conviction in that case? Because the law allows them to. You don't have to have corroboration. You don't have to have physical, material, documentary evidence. And you don't have to have brought a recent complaint. So, there you go. There is no meaning to the prospect of conviction at that point. It means nothing. So basically, if you're looking at it from the Crown's perspective, any historical sex case or any sex crime case has a reasonable prospect of conviction because of those things. So therefore, if we have really eager feminist Crowns, which we do, we have many of them, who are after a conviction at all costs and who know that their chances of winning a conviction are at least 50-50. It's half and half. It's literally a toss of the coin. Why wouldn't they proceed with these cases? Because they're going to get their gold stars every time they prosecute these cases and get a conviction. When all the variables come together, they get the right judge, they get a shitty defense lawyer, dump truck defense lawyer. The accused is stuck in jail, so he was never able to participate in building his own defense. The Crown throws multiple sex offense charges and eventually forces him to plead guilty just so he can get out of jail. These are all variables that can lead to a conviction, a wrongful conviction. And then you also have judges who don't help either. Because I've seen it with my own eyes. I question the power that judges have, or that they should have, or if they do have, but they're not using it for some reason. So the judges and the Crown seem to work together a lot. The judges seem to have more respect for what the Crown is putting to them than the defense lawyer. And in some cases, if you have a really bad defense lawyer, I could see that. But nonetheless, you would think the judge would do things or say things or halt things and admonish whoever needs to be admonished until, the judge can see that the accused person is going to get a fair trial. You would think. Well, all right, so in Canada, most of our sex crime cases are held judge only. There's no jury. However, we do have some that are jury cases. So I'm going to introduce you to a case here. And this case won. It was the conviction was overturned in 2016. And a second. There we go. Yeah. All right. So this case was appealed successfully in 2016, and you're looking at the Canley file. Okay. So it's R versus Warren, and there's the link here. So I'm gonna copy paste this. So I just put the link to this in the chat. Now note that this case has already been cited by 9 documents, and what that means in Canley, if you're not familiar, this is the public database of cases, case law. Cited by 9 documents means that 9 other cases have cited some language in this appeal to help their case one way or another. So I see some cases where there's 0 citings, and I also notice the HTTP, the URL link for them is dead. It's not hyperlinked. So I'm not really sure why that happens in some cases. So what that means is if you're searching using specific search terms, searching in Canley, the cases that are not hyperlinked won't show up in your search results. So that's kind of interesting. I'm not really sure why that is. So nonetheless, I did check this case to make sure it wasn't retried and ended up in a conviction or anything like that. It appears to not have been taken any further. So this case ended in an overturning of the conviction and a call for a new trial. But often there will never be another trial because of everything that comes out in the appeal. Is too strong of a case for the defense, and the Crown will then give up on the case. They'll then, do their little criteria checks and say, you know what, it's not worth it to do this again. So the charges may be stayed. So, which is not good necessarily. You want an acquittal. You want, when you win an appeal, you want your conviction to be replaced with an acquittal. If it's just put aside or set aside and then a new trial is called and then the new trial never happens, the Crowns usually just stay those charges, which means they're still just floating in your history, in your police history. They'll never disappear. So this case was, the conviction happened on 2015. When did it happen? Hold on a second. 2009. So he was convicted in 2009. And his appeal was overturned in 2016. That took a long time for this guy. I don't know what his sentence was and how long he had to spend in jail. But, that's really unfortunate. It took him this long. Yeah, I don't know. It's possible this case, he just delayed it for whatever reasons, maybe because he had to do several years in penitentiary, or it went all the way, it passed all of the other, he exhausted all of his initial appeals, and then the case got kicked back by a court, or by the Criminal Conviction Review Group in Ottawa, kicked back down to an appeal court. That is possible, but I'm not sure that that's the case here. Okay. Now, warning, this case does involve a minor child who claimed that she was sexual interference was the claim, and sexual assault. So the 13-year-old went on the stand, but claimed that the acts happened when she was 9, I believe, 9 or 10, or 6 or 7. Sorry, 6 or 7. So in a sense, this is a historical allegation, because she's claimed it happened when she was 6 or 7, but she was actually testifying when she was 13. So of course, there's going to be some background context on this that I don't know, But what I do know is what the appeal was. So the appeal was that the trial judge erred in failing to give a limiting instruction on the complainant's prior consistent statements, and the jury charge was unbalanced and favored the Crown's position. So this appeal panel allowed the appeal and overturned the conviction just on the first ground, that the trial judge erred in failing to give a limiting instruction. So one thing I don't like about the way we do appeals is we can submit multiple appeals to an appeal panel, and they will pick one. They can pick one that they decide will overturn the entire case, but then they won't discuss all of the other grounds. They'll just toss them aside, not relevant. I mean, I guess it's good because it's not wasting time or paper or reading time, whatever. But at the same time, I really wish, because I'm reading these cases and I'm thinking, well, that's a legitimate claim, you know, that the jury charge was unbalanced and favored the Crown's position. Why can't the appeal court make an opinion on that appeal, on that ground? But they don't. Anyway, so in this case, it was overturned on this one ground, and it was basically revolving around what's called consistent prior statements. You have inconsistent and you have consistent prior statements. So in general, in this case, excuse me, the 13-year-old told her story multiple different times to different people and in different ways. So she changed everything: the faces, the people, how many people, the positions, the acts, the place. Each time she told her story, it was something different. And even the acts themselves were pretty much physically impossible. And it was just a ridiculous claim. So the defense, basically made the argument that the Crown was wrong to say, the defense, argued that there were too many inconsistent statements and that this complainant is not credible. You should not, to the jury, you should not take all of these statements as, truth or anything like that. But the Crown said otherwise and said, well, the fact that this 13-year-old girl had the guts to tell her story to her grandmother and then to the police and to multiple people each time, it doesn't matter how different the story was, just the fact that she told her story multiple times is a prior consistent statement, and it counts as proof of the truth of her statements. And that's a no-no. You can't do that. You, as a Crown prosecutor, this person, I don't know if it's a male or a female, but that's obviously the wrong way to go about it. And it's obviously advocating for the child, and it's advocating for a conviction at all costs, even when you are presented with clearly inconsistent, not credible, and not reliable evidence. So the appeal panel here pretty much admonished the Crown for trying to save the complainant's credibility and reliability issues when you're not supposed to, and in a way that you're not supposed to. And that basically influenced the jury in a way that led to a conviction. So I'm sure there was a lot of emotions involved in presenting the case, plus a 13-year-old girl who said that, things happened to her when she was 6 and 7 years old. Nobody wants to know that these things are happening, and if we're being told these things are happening, tugs at our heartstrings, of course. But in the end, in a case like this, I would be absolutely relieved to realize, oh, this is bullshit. This never happened. And of course, there's always background context to the case, like family issues or something. the kids getting into drugs, or the kids not liking the rules of the house and finding a way to get out, or the parents put them up to it. One of the parents put them up to it. These are so common. I mean, I'm not saying anything shocking here. We all know this happens on a regular basis. The kids are often up to no good on their own. They're good at telling lies, but they might not tell the same lie over and over again. We know that. Or somebody else puts them up to it. They're influenced by somebody else that puts them up to telling these stories. So, here's a case where obviously this child tells the same story over and over and over again, but completely differently. And it was presented to the jury in a way that inconsistent statements, vague details, changing details, all of that stuff, I'm sure, was presented in a way of, these are signs of trauma. These things prove that this child was traumatized by these things. And we have precedents in our own case law that stand by that. R versus DD, I believe, is the big one. So, this is a case where you're looking at it going, how the hell did it end up in court? When she told the story so many different ways, and a story that didn't make sense, a story that was physically impossible, you would think that once she got past the police statement that would be case closed, right? But no, the prosecutor decided, because they know that the reasonable prospect of conviction becomes moot when you don't have a statute of limitations, you don't have a corroboration requirement, and you have forgiveness for inconsistent statements and vague details and things that don't make sense, incoherent narratives, and things that are told in non-chronological order. All of those things are forgiven. So, of course, the Crown has a reasonable prospect for conviction. And that also explains one last thing that I talked about earlier, and that is that the appeal panel still called for a new trial. You would think, in light of all of that evidence, why the hell would they even bother? Well, because I've seen this on many other judgments, and that is, given that a conviction can still be had, he could still be convicted, therefore I'm going to call a new trial. Instead of, well, he could still be convicted in a new trial, so I'm not going to enter an acquittal. Because it hasn't been proven that he didn't do it, necessarily, given all of those rules that I just told you. Or that because there's no corroboration requirement, no statute of limitations, and forgiveness for inconsistent statements, telling the story differently, giving vague details, non-chronological, non-linear narratives, all of that stuff, it doesn't matter anymore. That stuff that we typically associate with actual criminal behavior, now we have to associate that with proof of trauma, and not just us and the police, but the courts. The courts are doing this, and they have been for years, because this conviction happened in 2009. So Logic MK says it makes it look like they're just skimming the case, not actually looking at all the details. Yeah, well, that's very possible. I'm going to move my chat window over here so I can see it. Let's see. Okay. Okay. Like they're just skimming cases and not actually looking at them. Well, I think anytime a sex crime case comes in, they don't need to look at the evidence. They don't care. The police don't even do an investigation, as we know, because they don't have to. And they're also told not to go digging too deep. So the Crown knows they don't need, there's pieces of stuff that they don't need because, for example, a medical background on the complainant, therapy records on the complainant, child protection services files on the complainant, divorce filings or divorce proceedings and transcripts related to the complainant one way or another. The Crown knows that the cops aren't going to go looking for those, and the Crown doesn't have to go looking for those. They will let the defense make that move. It's up to the defense because it is the burden of the defense to subpoena those documents and have them entered in as evidence under an application hearing, a records production application hearing. The Crown knows this, so they leave it up to the defense. And you know what? It doesn't always happen that way. It doesn't always work out that way. Because the defense either A, isn't aware that that's what they have to do, their own attorney is dump trucking them and says, you know what? This complainant is full of lies and shit. She's just going to sit there on the stand and impeach herself. In fact, she already did 3 times. Don't worry. You don't need any witnesses. You don't need any documents. We don't need a private investigator. We got this covered. Don't worry about it. It happens, unfortunately. And then what the accused person doesn't know is that the judge and a jury don't need to have that evidence in order to make a decision. They can make a conviction based solely on the accuser's testimony. And that's what they do. So Phil says, some years ago, the Crown Attorney here in Ottawa said he would lay charges on every complaint without exception. I don't know if that is still the case, but I could tell you a couple of stories. He would lay charges on every complaint without exception. Yeah, well, I think that points to the morale thing under the Crown criteria that I was talking about earlier. So let's see. I'm going to try and get this on the screen here. All right, there we go. All right. So, yeah, I don't know why it's so small. Anyway, so the criteria here is right here on the screen. And likely effect of the prosecution on public order and morale or on public confidence in the administration of justice. So right now, feminist groups, the radical feminists, the feminist legal groups, feminist scholars, professors, academics, students, lawyers, prosecutors, victim advocate groups, women's shelters, well, they're the same thing, and sexual violence groups, they have all banded together, and along with psychotherapists who claim to have discovered neurobiology science that proves that lying and being evasive and telling the story differently, non-linearly, and vague details, and somehow that is all proof of trauma. Therefore, it is evidence that a crime occurred. Whereas another cop who's been doing this for 50 years could be watching this for all I know and agreeing with me. All of those traits and characteristics that they say make a alleged complainant of sex assault, those are the same traits that they encounter with a perp on the street caught in the act. They do the same things. Cop knows he's dealing with a criminal mind because they evade, They jumble their words, they jumble their thoughts, they jumble whatever it is they're spouting out of both sides of their mouth, right? That's exactly what these complainants do. But somehow, these pressure groups have all come together successfully and have influenced our courts and our crown attorneys to consider the public morale, the public order and morale and public confidence right now calls for every case to be taken, because we need more convictions. We need to show that we take sex crimes seriously. And it's all bullshit. Hi, Mark. You finally caught one of my live streams live. Yay. Let me get this out. Real Raven. Lay charges equals conviction, regardless of proof. A dangerous woman. Well, I'm not really sure exactly what you're saying, but yeah, so Phil's answering him by saying that he knows of 2 cases where, regardless of the proof, that the crime may not have occurred or that the woman is completely not credible, we don't know how many cases this is happening in. So the point of my channel is to introduce some of these cases to you, like the one that I just talked about. Each case that I show you is a symptom of a large problem, and these cases still continue. These are cases where the conviction was actually overturned, but I know of cases where no convictions were overturned. They should be, because they fall into the same categories of some of them that were overturned. So obviously in those convictions that are still upheld and stand up today, all of the variables didn't come together as they should have to properly overturn that conviction. Well, you can go even further and to say to make sure that that case wasn't prosecuted, brought to a court in the first place. So, yeah, basically laying charges is in Ontario anyway. It's pretty much the prosecution is, that much closer to their conviction. Okay, so Real Raven, you don't know exactly what lay charges mean. Okay. So basically that's what the police do. The police lay charges. So first they arrest you and then they lay charges. Technically, that's how it's supposed to go. So the charge is going to be a sex crime. You're charged with sexual assault. You're charged with sexual interference. You're charged with, whatever. And you get a charge sheet that lists all of the charges. And then that's what the Crown will prosecute you on. They will build their case around those charges. And they may evolve. So, Real Raven, I'm not sure, but this case that I read, in this case, was the judge a female? I don't know, actually. No, this judge was a male. There you go. Justice Raymond Harris is who convicted him in 2009 in this case, in this example case. Thanks, Phil, for elaborating on all of the other stuff that happens when you get charged. Mark says, I think there's a general misunderstanding of the role of our judicial system in our society. So much needs to be explained, and I think your approach is a real-world approach. More info than better. Well, thanks. I appreciate that. Well, yeah, because I think the fact that I didn't go to university for law, or actually I didn't go to university at all there, so there you go. I was not indoctrinated in any social justice kind of manner, or, you know, love thy legal system kind of manner. I never had an interest in it, really. I did work for a law firm once many years ago, but I did marketing stuff. But yeah, I had no desire to be one of them, none whatsoever. I had my own office and I got to do, you know, fun stuff. So I was fine with that. And, you know, the administrative people in the office I worked with were great. But the lawyers, you know, I didn't really want to have anything to do with them. But nonetheless, unfortunately, because a loved one got involved in the system, or I met somebody who had already been involved in the system. Yeah, I ended up learning a lot more about it than I ever imagined. And it was one of those things where I met them after they were convicted. So I was curious, well, do you have the transcripts? Yeah, you can read the transcripts. Okay. I'm like, you know, you're telling me you're convicted, but there was no proof. I don't understand. There has to be something. Where's the smoking gun? So he gave me all the transcripts and everything that he had available to him. And I read the judge's reasonings. It's the first place I started. And I'm reading through. Where's the smoking gun? There is no smoking gun. What the fuck? How can you be convicted with no smoking gun, so to speak? There's no proof of anything here. Just a decision was made based on the judge deciding whose story they believed. And they believed that the complainant was telling the truth. That's how she ended her judgment, her reasonings. Like, what the fuck? This can't be happening in real world. Like, this is real world? You know, that's wow. So, you know, thus from that moment on, it just led me into researching one thing after another, and then the next thing, and then attending hearings and going to courtrooms and talking to lawyers and talking to other people who've been caught up in this kind of thing. It just opened up a whole new world for me. And I mean, I can tell you it's not one that I enjoy, because it's very depressing and angering, but it's one that I feel, because of my experience and willingness to, I feel like I have a duty, basically, to raise the alarm and say things to people who are willing to listen, that, hey, this is what's really going on. This is how it actually works. It's not, you know, Law and Order on TV. And, you know, I just figured that's the best way to go about it, and just share my knowledge and talk about it, because I know other people are caught up in this stuff. And yeah, there's regarding the role of the judicial system, it's a big friggin' mystery, I gotta tell you. I really don't understand what powers that they have, or have used to have and have had taken away, or what powers that they do have that they don't know that they have, to control a courtroom and to ensure that a fair trial is occurring. That's something, it's really hard to find information on that and get actual answers from defense lawyers and whatever. It is a big mystery. Sometimes your own lawyer will just tell you we don't need witnesses or alibis to show because we have their statements. Yeah, that's another thing that a lot of people don't know. So if, let's say, the police take statements from a witness who you believe is proving your innocence, or proving that your complainant is full of shit. Well, the police may take their statement, and you assume that that statement is admissible in court. You figure, but that person's not necessarily available because they live in another town, or you don't want to disturb them because this is your shit that you got caught up in, and it's a really icky situation, and, you know, you really don't want to bother people and say, hey, you know, would you mind I'm having a trial right now, and, you could really be a great witness. Would you be willing to be a witness? These are uncomfortable conversations to have in some cases. And sometimes your lawyer will just tell you, you know what, don't worry about it. We don't need that witness. We have her statement. Well, then you find out that that statement is not admissible during the trial as evidence unless the person who made that statement shows up and testifies to the truth of that statement. So if you have someone who made a statement to the police on record, you can't just rely on that to be admitted as evidence. The person who makes the statement has to testify to that statement. So you need to take this case very seriously. Even if you think that this complainant is so full of shit, she's so, she's done so much cocaine, and, like she's obviously not in her right mind. Nobody's going to believe her. She's not going to be able to keep her story straight. You know what? None of those things matter. A conviction can still be had. So if you have a witness that already made a statement to the police, you need to take this very seriously, and you need to throw every piece of ammo you have into that trial and make sure that the judge or the jury sees those witnesses and hears their statements, and that their ears are filled with evidence telling them that the accused person is innocent, or most likely innocent at least. However, the judge can toss out any corroborating affidavit statements you supply if those who make them don't show up at court. Dump truck lawyers. Yeah. So if there's other corroborating evidence that you might have, as we know, Bill C-51 kind of highlights this. If it involves any personal record of the complainant on any level, you have to have a hearing for that. Your dump truck lawyer, if you have one of those, or if somebody else gets one, they won't proceed with those hearings to have these pieces of evidence admitted. And that brings me to a point. Regarding Bill C-51, I've seen some comments bandied about in various places regarding the fact that in those cases where the accused person has corroborating evidence or exonerating evidence, exculpatory evidence, that they didn't commit the crime, or the crime never occurred, or it was consensual, whatever the case may be, and if that record or piece of evidence is also a private record, considered a private record of the complainants, you then have to disclose to the Crown and to the judge that you want to admit that evidence as part of your defense, which is, like a Facebook message or video or anything like that. Like, this is a new thing that they've instituted. It used to be strictly limited to private records such as diaries and medical records and court records and things like that. But now it's been expanded to any communication between the two, or any communication that the accused, the complainant, is party to. Even if the accused person is party to that and it's in their own record, they still have to have this hearing. So one of the things that people are saying is, well, that's great, because that means that the Crown will finally see that the case is useless and that they can't move forward with it. They'll just drop the charges. The case will get tossed out right then and there. That can happen. Well, it can, but it won't always. In some cases, yes, I think it might happen. But by then, you've still already done so much damage to the innocent accused person at that point. So much damage has been done. Too much damage has been done. They're preventing the cops from accessing these records. They're bypassing the whole police investigation part of these claims and just shifting it right to court. And what else can I say about that? So It's such a shock when we learn that things are not the way we once believed. Yes, Mark. Yes, it is. It really fucks with one's brains, and everything changes in that sense. Suddenly, conversations that you're having with your friends aren't the same, and then you can't even have conversations with all of your same friends. They just disappear. They drop off. You don't even want to talk to them because you can't be bothered trying to explain to them all of these realizations you've come to, because they're just going to look at you like you're crazy or you're a conspiracy theorist or something. It is shocking, and it's completely life-changing. Like it just, I mean, for somebody who's witnessed it, not been part of it, but witnessed it, and actually had the whole cold, hard evidence. I had the opportunity to sift through it all on my own time, with no interruption. And I was also able to ask some questions about this or that or whatever, some clarifications, and realized how things get misinterpreted, misrepresented, mispresented, and the justifications that can be found in case law to say, well, you layman person, you might think that that's wrong, but there's actually case law here that says that's okay. Pardon me? So that's why I do the precedent stuff, the precedent videos, and focus on precedents as well. When it's getting to you, remember we're out here to give you a pickup. Thanks. Well, it does help to reach out to and engage with a live audience and people who care about this stuff as much as I do. Because I always have hope, that even if just one person, if my content or anything that I say just helps just one person, that makes all the difference. And I don't have to necessarily know about it, because I feel like every time I'm streaming these things or publishing my videos, that I'm earning karma points, if you will. And I'm doing something good. So, and having loyal followers helps a lot, and being able to chat with people. So Sean Doherty, I have heard defense lawyers talking down their own clients. Yes, and so have I. Ooh, do I have an example for you? Hold on. So here's an example. This happens a lot in these sex crime cases, where the complainant and the accused person might have been minors at the time that the alleged offenses occurred, and it may have overlapped into what would be considered adulthood. So, whatever the age of majority was in that time period, whether it was 14 or 16 or 18, whatever. So there's a case that I know of where that was the case. Was determining whether or not any of these sex crimes occurred when the accused person was a youth. Because obviously we need to take that case to youth court, but there's adult charges too. So, we have to split it into two. Well, in this particular case, the Crown decided to dump all the youth charges, just forget it. And then we'll proceed in adult court, because, I've consulted my law book and I've realized that I can't combine youth and adult charges in one court setting. So I guess I can't get away with that. So I'm going to dump the youth charges, and then I'm going to rewrite the adult charges so that there's more charges on the adult charge sheet, so that I can still have my big fat case with multiple charges. So the case proceeds in adult court, and in the defense submission, the defense lawyer and the accused person had no idea, was not party to this suggestion at all whatsoever. So the defense lawyer decided to submit in his submission that the Crown was not able to prove that these crimes occurred before the accused's 18th birthday. And so basically the defense was taking a position that he believed that there was a possibility or the crimes did occur before his 18th birthday, therefore you have to find him not guilty. No. This was not the defense angle the accused person was expecting. The angle was that none of this occurred. This is all a figment of her imagination that just arose out of a therapy office 25 years later. None of that occurred. But instead, his own defense, in his submission, took the position that these events may have occurred before his 18th birthday. Ew. Yuck. Yeah. So, yeah, defense lawyers, I've seen them advocate for the victim, the alleged victim, by calling them a victim. Just right there, calling them a victim is advocating for them. The defense lawyer should not be doing that. Yeah. So Mark Sparing says a great book for a general concept of liberal justice is The Structure of Liberty by Randy E. Barnett. Bit dry, but very informative. A novel by Solid. You know what? You can, if you want in your comments, you can, once this movie is uploaded, or once the stream is uploaded as a movie, as a replay, you can add some book recommendations in the comment sections, because I'm a big fan of people leaving their thoughts in the comment section, even if you might not think, it's a stale thought or whatever. You know what? People Google my videos and they stumble across my videos and they do what I used to do, which I still do, and that is I read comments. I read them, and it takes me down other rabbit holes, even if it's a book recommendation. And I can learn a lot just by reading other people's comments. So you guys should do that. Yeah. There's a lot of things I have to do to get more subscribers. I'm working on them, definitely, and it's working. I have been, the subscription, the velocity of it is increasing, so that's good. Yeah. So that I'm working on, and but yeah, what I really need though is, I need you guys to share my videos as well. Share it out with people. Talk about me on other people's channels in their comments as well. You don't have to leave a link to my channel or anything like that. Just name me. Clary Jaxon talks about A, B, or C on a video that's talking about similar content. If you guys do that as well, that helps, because then people will be curious, who's Clary Jaxon? And they might Google that and look me up, or search me on YouTube and find me. So you guys can help a lot too by spreading the word, sharing and liking all of my videos. Of course, if you like them after you've watched them in full. View time matters, of course. I need people to actually watch my videos in full. So, of course, I'll be working on, I'm always working on tightening up my content. That's for sure. Yeah, speaking of books, I have a list of books that I would like to start introducing to my viewers, and just sort of say, like, here's some good books on topic A, B, or C, generally the Canadian justice system, because that's been my focus. I'm going to do that in the future, but I did promise that I was going to reveal the source about prosecutor discretion and prosecutor ethics. So yeah, I'm totally going to share that with you guys, but I'm also going to share it when I upload this as a replay video, I'm going to share the link in there as well, in case you don't get it here. Let's see. The YouTube channel is called Legal Ethics Podcasts, and they only have 291 subscribers. But what I believe this channel is a local Canadian, I don't know where in Canada, but a Canadian law professor who uploads podcasts for her students. But these are very enlightening, and for anybody who is doing research for their own case, or for somebody else's case, or even the layman person who wants to understand legal ethics, this channel is great. You need to go to this channel, and I'm just going to put the link for this video that I got this from into the chat room. Hold on a second. Copy. All right, so that's the link for this video. Yeah, so Legal Ethics Podcasts. Go subscribe to this channel. Make some comments, but, you know, make sure they're, watch your language or things like that, or I wouldn't ask about your own specific case. How, you know, this channel is not the place for, can you help me with my case kind of stuff. This is more a presentation of our legal system from a legal scholar perspective. So, for example, lawyer speech, a review of the lawyer's ethical obligations in relation to public statements, the duty of civility generally, criticisms of other lawyers and criticisms of the courts. Prosecutors, a description of the ethical duties of Canadian duties generally and in relation to disclosure and the exercise of prosecutorial discretion. And these things are important because they can be used in appeals. They can be used in a courtroom. You can have your defense lawyer declare that the Crown is misbehaving in some manner according to these legal ethics. Lawyer-client conflicts. This can help people understand the relationship between lawyers and clients. Regulation of lawyers. So this stuff is very useful. I may be pulling stuff from here from time to time, but yeah, I highly recommend you go to this channel, subscribe, and it's just a great resource. What else can I say? For Canadians. Probably for UK folk as well. Anybody who uses the common law legal system the way we do. The Crown prosecution system, it's very, very much the same. All right, guys. Well, I think I've covered everything. Do you have any questions for me or anything you want me to answer before we sign off for the night? Alrighty, guys. Well, thank you again. And yeah, I hope those of you who live in Toronto have enjoyed this lovely spring-like day. But winter will be here soon enough, and we're all going to be miserable for it too. But I'll just keep making videos. How's that? Alright, guys, as always, take care. It was great to see you guys and engage with you all. So yeah, anybody who's watching this now who isn't subscribed, if you want to get notifications, subscribe, hit the notification button, and make sure you're notified every time my live streams go live or I upload a new video. All right? Cheers, everybody. Have a good night.